Good morning, everybody. We have started this web series to bring to the notice of the listeners the whole of the Constitution, highlighting wherever it was misunderstood, misused, misapplied, as a result of which the country is facing political instability, political uncertainty, political immorality, social strife, and poverty. Until the previous video, we have completed up to Article 187. Today, let us discuss Article 188, which relates to the oath of office to be taken by the members of the state legislatures. Oaths of office of different constitutional authorities is the most important one to know, and of course, it is also the most neglected one. Indian judicial experts, polity press, and intelligentsia have forgotten to refer to their oaths of office. Under Article 188, every member of state legislatures, be it assembly or the council, will have to take a oath in accordance with Schedule 3 of the Constitution in the presence of the governor of that state or his assigns. If anybody sits in the assembly without taking oath, he is liable to pay penalty of rupees 500 per day. State legislative members take oath before the governor or his assigns. The same way, union legislative members, the House of the People and the Council of the States, they take oath before the President or his assigns. So, taking oath from legislative members is a function of executive. In India, executive means the President and governors of various states and their appointed subordinates who are called executive in public service. Even the disqualification and removal from membership is the matter of the executive. In terms of Article 103 and 192. Under both these articles, it is the President at the union level and the governor at the states level who will decide the issues of disqualification of members of the legislatures, and their decision shall be final. Unfortunately, in 1976, through 42nd constitutional amendment, it was added that the president and the governor, before taking decision, shall obtain opinion of the Election Commission of India in case of the union members, and in case of state legislative members, the opinion of the opinion of the State Election Commission shall be considered by the governor, and he shall act according to opinion of the State Election Commission. You see how this language is misused, misapplied, and misused. It is the absolute right of the governor of that state to decide upon the disqualification of members. So 42nd Constitution of 1976, it was added that, however, the governor shall act on the opinion of the State Election Commission. So the opinion of the State Election Commission, who is appointed by the governor himself, is binding on the governor. It is only the opinion of the Election Commission. How can be it an order or command or direction to the governor? And in fact, such a condition as imposed by 42nd Constitutional Amendment of 1976 was unwarranted. Let us see how the oath of office of state legislative members run. I so and so, being elected as member of the state legislative assembly or the council, do swear in the name of God that I bear true allegiance to the Constitution and uphold the sovereignty and integrity of the nation. I will faithfully discharge the duties about which I am going to enter. So the main essence of this oath of office is to bear true allegiance to the Constitution and uphold the unity and integrity of the nation. This is also the same oath of office taken by the union legislative members, whereas it is different for the judiciary. The Supreme Court judges take oath as follows. I, being appointed as the judge of the Supreme Court, judge of the High Court, Attorney General, Advocate General, or Election Commission, do swear in the name of God that I bear true allegiance to the Constitution of India and uphold the sovereignty and integrity of the nation. And I faithfully and to the best of my knowledge and ability and judgment perform the duties of my office without fear or favor, affection or ill will, and I uphold the Constitution and the laws. In addition to the oath of legislative members, the ministers take an additional oath of secrecy that they shall not divulge the information which comes for their consideration as a union minister or state minister. We know the oaths of office of the President of India and the governors of various states are contained in Article 60 and 159. They read, I, to the best of my ability, preserve, protect, and defend the Constitution of India and the law, and I devote myself for the service and well-being of the citizens of India. This is a lofty oath, and such oath is not prescribed for anybody under the Constitution. The oaths of office of President and Governors are contained in the main body of the Constitution in Article 60 and 159, whereas the oaths of office of all other members. These oaths of offices are contained in Schedule 3 of the Constitution. Thus, please understand the Constitution has taken every care to draw a distinction between the executive and all other constitutional authorities. If you see the hierarchy or the serial in which these oaths of office are contained in Schedule 3, you can come to a conclusion as to the importance given to each of these constitutional authorities. First comes the oath of office of the executive in Article 60 and 159. In Schedule 3, at serial number 1 is the oaths of office of union ministers, and comes next the oaths of office of secretaries of each ministry, and then come the oaths of office of Supreme Court judges. Then come the ministers of the state and secretaries of each ministry, then members of legislative assembly, and lastly come oaths of office of High Court judges. If you look at the serial in which these oaths of office are contained in Schedule 3, you can understand to whom the Constitution has given more importance. If you see the oath of office of President and Governors, they say that they would preserve, protect, and defend the Constitution of India and the law, whereas all others take oath to bear true allegiance to the Constitution and to uphold the sovereignty and integrity of the country, whereas President does not take such oath, and governors, of course, because in my opinion, they are the sovereign powers of this nation. The Supreme Court, having taken oath to truly abide by the Constitution, cannot ignore the constitutional or the legal provisions. So, to preserve, protect, and defend the Constitution is the responsibility of the executive, namely the President and the governors, but not that of the Honorable Supreme Court. Had this been considered, the judgments in Keshavananda Bharati case and S.R. Bommai case would have been different. We are considering these two judgments as landmark judgments, but in my opinion, they were delivered without considering the oaths of office of the President and Governors, the judiciary, and other ministers, etc. So, it is necessary to understand the oaths of office of different constitutional authorities and to understand who is responsible to preserve, protect, and defend the Constitution of India and whose duty it is to bear true allegiance to the Constitution. Thank you. Thank you for watching my video. I will be coming up with explanations on each and every article and highlight if there is any deviation, misconception, misinterpretation, or misuse. I request you to please subscribe, share, and comment on my videos so that the constitutional message will spread faster and wider among Indian citizens, and I hope that there shall accrue social, political, and economic change in India for the good of the country. Thank you.